All right, hi, and welcome back. Attorney Steve Vondran, software infringement lawyer. We are talking in this episode about Siemens PLM lawsuits, product lifecycle management. This is general legal information only and not legal advice. If you need specific legal advice, give us a ring, and we're happy to give a free consultation if you received a subpoena or a notice of subpoena or notice of a federal court lawsuit. Okay, first question people will ask me is, how did Siemens find out about this, about software piracy? Well, basically, what typically happens is it's an illegal download through some sort of piracy website or torrent website, and a client, an engineer, let's say, will be downloading the NX products or the Solid Edge or some module add-ons. And when that happens, a unique identification is created. And so when you log in and to use the software, basically there's what we call this phone home technology, which when you try to log into the Siemens servers, it's going to identify your computer. It's going to match it against their licensing database. If there's not a match, your IP address is going to be flagged. Okay, so each instance of every time you log on, each instance is going to be recorded. So if you're at your boss's place of employment or you're the employer and you're logging in from the office, that IP address is going to be logged. And essentially Siemens is going to go to your internet service provider and find out your name, your identity, your company name, so forth and so on. So some of the potential defendants can be engineering students using software commercially. Let's just say on side collaboration projects, that's a possibility. It could be corporations that are logging on using the software with some 3D printing tools. It could be a corporation benefiting from a student bringing a laptop into the workplace. That's another one. It could be engineering students that are learning job skills in between jobs. It could be non-engineering students, such as roommates, tinkering around, playing with the software. So there's a lot of different potential defendants that can arise in these cases. And again, if the corporate IP address is logged, then that could implicate the employer, which for Siemens is not what I would call the classic traditional copyright troll, software troll, more of a licensing model, wanting to get clients licensed. And for a big company, if they catch a big company downloading and using the software, then it could be something where they're seeking damages, infringement, monies, attorney fees, but also to get the company licensed. So, those are some of the potential defendants. Subpoena notice from your ISP. Again, this is where you get the letter. It looks like the Siemens has filed a federal court lawsuit is typically the way it goes. So the lawsuit's been filed, and a request for early discovery is made on the ISP, and the federal court judges are routinely granting these. So Siemens is then allowed to serve a subpoena on your ISP, and the ISP is being asked for your name, your address, your phone number, any other identifying information. So you have to read closely what the subpoena says and what they're looking for, so you understand exactly what it is that they're looking for. So they want to find out, essentially, are you one of the engineering students? Are you the corporation? Who exactly is doing the downloading? Who exactly is using the software? What are they using it for? Or do they look like a viable litigation target, or is it somebody couch surfing on looking to use the software, just sort of tinkering with it, as we've been told from some of our clients. So so they may run an asset search. They may try to find out if you're worth going after, if you're judgment proof. But like I said, lots of times they're looking to get clients licensed or seeking infringement fees. Do you challenge the subpoena? Well, you'll see lots of websites out there that say go do the motion to quash or go seek a protective order. Generally speaking, not to say you can't do those. There may be a circumstance, say it's you're being sued in Houston, Texas, and you've never had anything to do with Houston, Texas, and you're out in Boston, Massachusetts, or New York, or Seattle, anywhere else, and you basically say, well, there's no jurisdiction. You may want to talk to a federal lawyer to talk about whether you would want to file a motion to quash. But there's been a lot of motions to quash that have lost. Motion for protective order to keep your identity secret. some of those protective orders have not gone through either. So you have to sort of look at the situation and see if there's good grounds to make that challenge to Comcast or your ISP and challenging the subpoena. Or you might, and also as I note here, you want to weigh the costs of that versus your chances of success. So if you're going to pay $1,000 to $3,000 for a motion, whatever the case may be, weighing that versus your chances of success, okay? Because if you file a motion, that could be opposed and you could have a hearing and everything else, so that can be costly. You also want to figure out, like a lot of clients will just say, look, I just want to get these cases settled. A lot of our software clients will just say, I just want to move on, get this settled for cheap, confidentially, and I don't want this to wreck my career. So these are some of the things that we talk about if you have questions in that area. Staying anonymous, obviously that's an important factor. Everybody wants to keep this a secret. You don't want your employers finding out. You don't want future employers, if you're one of the job seekers, in between jobs, you don't want your future employer to do a background search on you and say, hey, were you involved in a copyright infringement lawsuit in Houston, Texas, Southern District or Eastern District? So you want to be careful about that. But as we say here, it's best to keep your name out of a lawsuit. And you can do that by seeking an early settlement, trying to get your case settled without opposing it, without filing a motion to dismiss or, basically filing an answer and trying to defend the case. Of course, that's always an option. You can do that if you want. But again, I have found in the software cases that we've handled, seeking anonymity from the opposing counsel is usually something they're willing to agree to. Okay, and again, if you're going to settle, obviously one of the terms you're going to want is to get confidentiality in your settlement agreement. So that's an important factor when you get to that point. Negotiating a quick settlement, that's an option. The attorneys for the other side, this case may have been filed by Reed Smith Law Firm. The last case that was filed has 100 DOE defendants. That's 100 defendants. So they're working hard, working overtime. So if you come to the table with a good, clean offer, sensible story, they will be willing to work out deals with you. And so that's why I say exploring a quick settlement is always an option. In fact, it's what a lot of clients want. Just, yes, I've used it. Let's get this settled. I just want to be done with it. Okay. Settlement amounts, they can depend on the nature of the alleged infringement. They can also be based on the financial condition of the defendant. And as I note here, there are some creative solutions possible, and we can discuss those in your case. Defending the lawsuit, of course, that's always a possibility. You can raise defenses such as, I didn't do it, must have been my neighbor, unsecure Wi-Fi, it could have been anyone else, it wasn't me, trust me, I would never do that. You can have students raising fair use issues, and fair use is basically, an exception to the copyright laws. If you're using something, for scholarly research purposes, for example, you may be able to make an argument that it's a fair use under the copyright laws. You may make a statute of limitations argument. There could be other defenses depending on what's going on in your case. Again, give us a call. We can go over the copyright infringement defenses with you and have a discussion about that. Again, you always need to factor in the litigation costs. If you're going to be taking it to trial and you're going to try to prevail. We have had clients in various download cases say, I'm not paying this and I want to fight. And if they won't dismiss the case, I'm going to go file a lawsuit. I'm going to essentially litigate the case, and then I'm going to seek my attorney fees. So that is something that, can happen, and sometimes that can force a settlement. So, and we'll get to that in a second on attorney fees. Potential damages for software piracy. What are the penalties and fees, and what may you be facing? What type of liability? Innocent infringement, if you can show that you had a good faith belief that it was non-infringing or some type a fair use in good faith. You may be looking at a $200 minimum, but again, that's a high hurdle. You're going to need to show that you had absolutely no idea, that you thought in good faith. Maybe you sought the advice of an attorney, and that you had good faith belief that this was non-infringing. That may be a very low penalty. But again, you may have to litigate to prove that. So that can be expensive to get down to that minimum. Non-willful infringement, that would be something that's not innocent. You could be looking at $750 to $30,000 per infringed work. So of course it starts getting expensive at this level. And if they prove willful infringement, just blatant, using their software without licensing, pirating, crack codes, thumb drives, up to $150,000 for willful infringement per infringed title. So if they have several different titles like the NX7, NX8, Solid Edge, those are all different titles. So you could be looking at $150,000 plus attorney fees. And I put a little note here on defendant's fees. A question I get often is, if I fight, and I win the case, I prevail in a trial, let's say a jury trial in federal court, can I seek my attorney fees? And the answer is yes, you can seek your attorney fees in copyright under the copyright laws. The attorney fee statutes are what we call two-way. So two-way. So if they win, they can seek their attorney fees. If you win, you can seek your attorney fees. Again, you need to weigh the cost of litigation, the likelihood of prevailing on your defenses, and other factors, okay? Officers and directors may be held liable. We can talk about that if that's an issue with your company. And if you've been using their software and making a tremendous amount of profits over a number of years, don't be surprised if they say, hey, we want to recover some of our profits here. You have been making money for a long time on our backs, and we want to seek some of those profits. So they can seek their actual damages and those kinds of things. So those are typical things that you may hear when you're dealing with software piracy. Southern District Court of Texas, that's a federal court in Texas. We've seen some cases filed. There's a new one. This is the case right here. You can see it 416-CV03552. There is 100 DOE defendants. There's 100 IP addresses. And really a DOE defendant is just somebody, they don't know your name, identity. They don't actually know who you are. And so, they're naming DOEs. Once they ascertain your name, if you don't get your case settled, if you're not able to settle the case after they get the subpoena information, then they can always amend the complaint and start adding names. So that's what it means by the DOEs 1 through 100. Again, cases you may see filed by the Reed Smith law firm. We've seen other cases filed in New York, Pennsylvania, Ohio, and the Eastern District of Texas, as well as the Southern District. That's about it. If you have questions, if you received a copyright infringement notice or you were served a summons and complaint, we can help you try to explore your defenses, review your options, take some of the stress off you. You're not sure if you want to respond to the letter, or you're not sure if you want them to take a default judgment against you, if you want to talk about finding ways to reach an early settlement or what type of settlement solution we may be able to achieve in your case, give us a call. I've got our number there. I've got a link to our website there, softwareinfringement.com. And as it says here, we're experienced in software copyright matters. We handle a lot of cases with various vendors, including Microsoft, Autodesk, Siemens, Vero, Mastercam, so a lot of different types of companies. So if you need some help, give us a call, take us up on the free consultation, and we can talk about our affordable legal representation. Okay, this is Attorney Steve Vondran. I appreciate your time. If you enjoyed this video, feel free to share it on your social media networks, and don't forget, subscribe to our popular YouTube channel. We're growing fast, so we appreciate having all you people coming on board and helping us out, okay? Thanks a lot. Have a great day. We'll talk again.